I think we'll begin with our session, and I would like to introduce our speaker and our faculty to you all. Hi, and very good evening, everyone. Welcome to this session on patent law. And we have with us Mr. J.L. Anil Kumar, who is an expert on intellectual property and patents in particular. He has an extensive experience in patentability in the engineering field. Anil has over 36 years of industrial experience in the field of quality reliability assurance of a variety of electronic equipment, research and development at Kirloskar, Mysore, and over 23 years of experience in intellectual property. Anil is a BE Electronics and Communication and MTech IIT Kharagpur. Anil's areas of expertise are in IP strategy for startups, patent drafting and prosecution, in assessing patentability of ideas and advising researchers and developers in improving and strengthening their inventions and patents. Welcome, Mr. Anil, to EBC Learning, and we are so looking forward for your session. Without any further delay, I'll just hand it over to you, sir. Thank you so much.
Yeah, thank you. Good evening, everyone. I had prepared a very quick introduction to myself, but I think that Rachel has already done a very good job of it. So let's continue to the next round. So this is session outline. I'm going to talk very quickly about patents. We recap about what we already know. I'm sure all of you know what it is. But we'll just take as a platform, we'll just take a quick look at that. And then I'm going to talk about kinds of patent applications, patent filing and prosecution steps, patent filing and prosecution timelines, other actions to be carried out. I'm going to give only examples there. And we will look at the contents of the patent. And there are two other things, patents of addition and divisional patents. Then secrecy and prior art, and a look at invention disclosure. That is only if it is required or the time permits. So this is not really a part of the whole thing. So this is what we are going to take a look at today. So what we already know about patent, it's going to be a quick refresher. So what are the basics about patents? Patent is an exclusive right granted by a government the owner of a new invention to exclude others in the territory covered by the patent from making, using, offering for sale, importing, or selling the invention without the patentee's consent. This we all know. This is the important parts have been highlighted. It's an exclusive right. It is granted by the government of a company, of a country, and it is granted to the owner, not necessarily the inventor. And it must be a new invention, which might look strange, but it is how the patent law defines it. And then to exclude others in the territory covered by the patent by doing the following actions. That means that if anybody does any of those things, it's called infringing on your patent. So that's not allowed. So how long does this exclusive right or monopoly, as it used to be called, exist? It exists for 20 years from the date of the filing of the application. So for the patent to be granted, the invention must fall under patentable subject matter under the applicable law. This is more or less the same in all over the world, but each country might have a slight variation in how they look at what is inventable. What is patentable invention. But anyway, this is important that there are rules and regulations as to what can be patented and what cannot be patented. One example would be that if it is something with the main purpose of which is harmful to the life of a human being, for example, it cannot be patented. So things like that, there are a whole list of them that cannot be patented. Then the invention must be new or novel. That means it has never been done before, or it has never been published before, or put into use in a public domain. So that is a very important one. And then there's the invention must be non-obvious, or it must have an inventive step. So non-obvious is that non-obvious to a person skilled in the art, which it's a whole subject by itself, who is that person to whom it is non-obvious. So we can think about that person as a laboratory technician who, given the instruction, for example, a patent, will be able to put that into practice. So for now, and the person doesn't have an inventive spark. That is how at least the Indian patent law defines it. So it must not be obvious, but in India we have a special class which is economic significance. This is mainly because if you go back in history, where this patent law was formulated when India was a very poor country, and then any economic significance that the country would get, I mean, it would get the people of the country would get that economic benefit, and hence this has also been allowed in India. Then the invention must be useful, which is obvious. It must not be frivolous, and it must have utility or industrial applicability. This is another way of looking at it. Now we'll take a quick look at uh, the two kinds of patent applications that a patentee can, a prospective patentee might apply for. One is called the provisional specifications, and the other is called the complete specifications. When we talk about patent filing and prosecution, we're invariably talking about complete specifications, but it is very important to know about provisional specifications. You apply for a for a patent with a provisional specification when you are still in very early stages of an invention. You know what the overall look of that invention is like, but it is incomplete. That means there are nooks and crannies and nuts and bolts which are not finally, uh, you know, you don't have a complete picture about it. You know that this is an idea that can work, and then you probably can publish it as a paper, but instead of before doing that, you apply for a patent. But this is called, sometimes it's called a dump application. The main objective of this is to obtain a priority date, which is a crucial and extremely important as item in a patent's life. That means, when did you make this invention? Because the day before whatever is published, even a day before this, will be treated as prior art. So we know that priority date is an extremely important date in the whole life history of a patent. Then the provisional specification describes the invention with such detail as available at the time of application, and it contains no claims, because claims are the heart, or the legal heart of a patent document. So this doesn't claim. That means we don't say exactly what we are seeking protection for. So a provisional specification need not contain any claims. Quite often, when you are in a hurry, you might even uh, make the application with a journal article, for example, that you might have submitted, and that can be submitted as a provisional specification. The other important thing is that all patent applications will be published at some time or the other, except the provisional specifications. That will never be published. And there is no great grant based on this specification. And but it gives you the right to say that on the product, if you are having a product, you can say patent pending or patent applied for on the product without incurring any. Uh, the law doesn't look at you askance if you do that. Now, coming to the complete specification, which is the of the great interest to us now, if complete specifications are filed when the invention is complete. That means you are sure of all the details. You know what to do, how to do it, and what will be the final, how it operates, how it functions, how it will be used, everything. So that is the kind of invention that will be filed as a complete specification. The purpose is not only to obtain a priority date, but it is also to obtain a grant of the patent. That means the patent would be granted to you. So it describes the invention completely in all respects. This is a very important thing that we should know, that a patent must contain enough information for a person skilled in the art to execute it without undue experimentation. So these are all important terms that go in there. For a person skilled in the art, based on the patent, you should be able to practice it without undue experimentation. That means you can't leave out things and keep secret stuff that prohibits somebody from using your patent. And it contains claims, and you can claim patent pending as in the earlier case also. So that is about the patent uh, per se. What does a patent have? What is it all about? One way of looking at a patent is to say that it is a technical solution to a technical problem. That is the simplest way of thinking about what can be patented. That there should be a for the existing art or in a new uh, there is a society is facing a problem in doing something, and you are providing a technical solution to that. That can be patented. Or there is already a product, it has some deficiencies, shortcomings, etc., and then you are overcoming that by your invention. That can be patented. So, what are the patenting process? If we take a step by step approach to this and see what the uh, patenting is all about, you conceive the idea of a patent. That can happen in the laboratory when you're working on something or you're thinking about a problem and then a solution occurs to you. And that is the conception part. It's people also call it ideation, but the main idea is that it is conceiving the idea of what you are going to patent. What is the technical problem and what is the technical solution that you are going to give to that problem. Now, you might go ahead and do some proof of concept kind of thing. You implement it, or try to put it into practice and make sure that it works. But it is not absolutely necessary. If you are convinced completely that it is going to work, then you can apply for a patent. Here again, one of the things that cannot be patented is that something which violates the known laws of science cannot be patented. For example, the most obvious example is a perpetual motion machine. That means the system which receives less energy than the energy that it gives out, which violates the second law of thermodynamics, that cannot be patented. So there are still lots of people apply for patents for that, and it will never get granted because of this reason. Now, the next step is that you write up a disclosure document. This is called invention disclosure, uh, uh, disclosure of invention. There are many, many terms that people use. So you write the disclosure. That means you completely describe your invention in completely technical terms, give all the details, you use figures, etc., etc. Now, the next step would be to refine the ID with the help of a patent counsel. This is not a necessary step, but it is always good to take the help or consult a patent counsel who might, especially if he or she is in the domain, it will be of great help. Next, move towards. Yeah. Now, the next step is also optional, but it is something that is recommended because you see whether this invention has already been made by anybody in the world anywhere, right? So because we saw that in the uh, when we are describing what can be patented, it says that it is a new invention. You might think that you have invented something new, but there might be somebody who has already published it or put into practice or sold it already in the market or displayed somewhere and all that. So it is better to do a prior art search. Interesting thing in this is that it's sometimes a policy of the company in which the invention has been made. One famous example is that IBM hardly ever does any prior art search. They can afford not to because they know that they're in the forefront of technology and nobody else is even uh, anywhere near close to what they've been doing. So they don't do a prior art search. But other people, like many other companies, they do a prior art search mainly to make sure that they don't spend loads of money to get a patent, and then the patent office comes back with the prior art saying that you cannot patent this. So there's a prior art at the next step. Now, this is a loop kind of thing. You compare the ID with invention disclosure with the prior art, and then see whether your invention is actually new. If you don't find any prior art, that theoretically means that your invention is new and you are likely to get a patent. Sometimes what happens is there are patents or other literature which is close to what you have invented. Then you might modify the ID so that it has inventive step and novelty both can be enhanced by doing this kind of thing. And then if you find absolutely perfect prior art for whatever you have done, then you abandon the invention disclosure. So you don't do anything about it. So if you are convinced, reasonably convinced that the patent, the whatever you have invented is new, you take it, you decide to apply for a patent. So this is where the loop comes. Many times, what happens is after you modify the invention, we do another top-up search. Some people call it, and then it can be searched again to make sure that that element that you have added anew has not been done by anybody else. Now, based on your invention and the disclosure, either a council or anybody will draft the patent specifications. Now, there are two options here. The law allows an inventor himself or herself to draft the patent specification, or he or she must be a registered patent agent in India. Different countries have different names for them, but people who are authorized to do this only can draft and submit the specification. When I say draft here, write the patent specifications and also submit it to the patent office. That can only be done by authorized persons. Then, after drafting the specification, you submit the patent application at the patent office. Then, statutorily, once the patent office you submit it to the patent office, it lies dormant for 18 months. This is a legal requirement because if you are an individual inventor, let's say, and you have already invented and you know that you are going to put this product in the market, you should get time to gather finances to do this, establish a factory or whatever, and then get suppliers, make this and start selling it even before anybody else comes to know about it. So that's the reason why the patent office, patent law gives you 18 months time to before the application is even made public and anybody can read it. So now after that you get the patent application published. Then you have to ask the patent office to examine your patent. In India, it is called, you have to pay a fee and fill out a form and request the patent should be examined. Of course, you should also make an application that the patent be published, right? And then you get it examined. The examiners at the patent office will go through your patent application in all detail, including technical and formal requirements, and then you get an examination report. In India, it is called a FER. It's called a first examination report. The examination report might show many lacunae in your patent application, both technical and formal ones. For example, it doesn't know the inventors' names and addresses have not been given, or the whole thing is not in the proper format, whatever it might be. And then also technically, they will examine the thing and they do a search. The examiners do a search for prior art and then compare your patent application with the prior art and then determine whether this patent can be granted or not. Quite often, the first examination report will say that it cannot be granted for so and so, so and so, so. They will list out detailed report you will get. Now, in India, you have 1 year's time to put this patent application in uh, due order, as it's called, within 1 year. That means you can change the claims, modify the claims and all that, but you cannot add any new material to it. So you can, whatever are the defects that has been found by the examiner, you can correct them. And then if the patent claims are show that there is prior art, you can change the claims still within whatever has been described in the rest of the patent, and then try to get uh, argue for your case that with the patent examiner and say that because of these reasons, I should get a patent. So this is called the prosecution process, right? So you act on the examination report, and it might take a few iterations, and then after that, in nowadays, especially with Zoom and other such tools are available, the examiner or the patent office can ask you for a oral hearing. That means you can argue the case with the examiner on a call, and after that, it can be it is either granted or rejected. Right? There are only two outcomes to this. So you have made all the changes as that satisfies the examiner that your patent can be granted. The patent will be granted, or if it doesn't meet the required requirements, it is rejected. Let's not look at the rejection portion right now. If it is granted, you will pay the fees. See, the patent comes into effect from the date of application. First of all, for 18 months, you have the patent has been dormant. It has been it's not been published. After that, you ask for the examination. Depending upon the workload of the patent office, it will take 1 year or 2 years or even 3 years before the patent application is examined, and you get the report, and you have time to put the whole thing in order. So it'll take about, let's say, 4 years or 5 years from the date of your application for you to obtain a grant. Then what happens is once it is granted, your patent is already in process. It is effective from the date of your uh, application. So 5 years you have to pay maintenance fee for this. Every year you have to make sure that the patent will continue for 1 more year, and hence you because it's already 5 years since the date of application, your maintenance fees are already due. So you have to pay that. You pay the maintenance fees, and then the patent office will issue the patent. They will publish it in the journal, and then they grant you letters patent, which will be like a certificate that you receive. And then for the next remaining term of the patent, that is for the 20 years, assume that you got the patent only after 5 years after your application. For the remaining 15 years, you have to keep paying the maintenance fees so that the patent is effective. So these are the steps that any patent up to grant will take. Are there any questions at this point, or shall I continue? Okay,
Continue, sir.
looks like, yeah, I'll continue. So this, whatever I have talked about till now, I've just put it into a slightly different form to show the same thing. So we'll go through very quickly. Prior art search and patentability search. There's a draft patent application. Prepare all the forms, because like any government work, you have to fill a lot of forms. You prepare those forms and then file the patent application. Most of this work is done by the applicant or the patent agent or the attorney, whatever you call it, patent counsel or whatever you call it. So these are the steps done by the applying parties, let's say. Then publication after 8 months, and examination and patent grant or rejection. These are the steps done by the patent office. Here, we'll come to that a little later. Then maintenance and annuity fees for 20 years, that is done by the applicant or the patent agent or the attorney. They do it on behalf of the patentee. So these are the steps, and who does what. So, as I said earlier, the inventor himself or herself can draft the patent, which is allowed, and nobody, no other person are not authorized by the government can draft the patent and apply. And then the prior art search, it is better done by experts who do this day in and day out. They know how to do this. They have nowadays even AI has started helping in the uh, search function. So that will be done, and then these are the steps that the patent office takes. Now let's look at the uh, timing of this. How much time it takes, and where are the uh, what do you call uh, milestones or the steps. I think in modern terminology, there's a gates. So you conceive the idea and then you take time to reduce it to practice or think about it, discuss with your colleagues or whatever. And then there's a certain amount of time. This time is not, there is no limit on this time. You can take as much time you want, but sooner the better because as I said, when we apply, there is a priority date, and that is very important. So you have to make the priority date as early as possible. Now you write the disclosure that can take anywhere between 1 day, depending upon how for you're placed, and then it can take a few days or a week. And then there's a search to be done. So depending upon how good the searcher it is and how busy the searching authority is and all that, it will take a few days, let's say a couple of weeks. And then you refine your invention disclosure, and then you start drafting the patent application. Then you file the thing in the patent office. Then there's a that is the priority date. The date of filing is the priority date. And then for 18 months it stays in limbo. It is not known to anybody. And then after that you apply for the examination to be done, and the examination takes place. And then you receive the first examination report. And then the prosecution period, that is theoretically 1 year. You have maximum time. Sometimes it can be much shorter, or you can if they depending upon how fast the patent office responds, it can go further down also, but usually it is 1 year. And then you make sure that that's why I've shown a feedback loop kind of thing here. So there are a couple of iterations, and then there is the oral hearing or whatever, and then there's a grant or reject uh, decision, and then it will be published. The granted patent. So before grant, there is a publication. After the grant, with all the changes, the final one is also published. So that a person who reads a granted patent knows exactly what is being protected. So this is more or less the overall uh, time cycle that is involved in a patent application. Now we have talked only about patent making patent applications in India, but if you are also trying to apply for the same patent in multiple jurisdictions in different countries, then what happens is you will have to do all the foreign applications within this time period, within the 12 months. This is not 18 months. For that, within 12 months, you can apply in any of the PCT countries. That means for Patent Cooperation Treaty is signatory countries. You can go anywhere and then apply for that, which is done within 12 months after the priority date. But the rest of the thing remains more or less the same, right? But there is another route in which you can make multiple applications in different countries with much. Just a moment. This is time for my medicine, and I'll take that and then I'll continue. Right. So if you want to apply in multiple countries, there is an alternative route which is known as the PCT route, and we'll take a look at that. So here, what happens is all the earlier steps that we talked about drafting, up to drafting, it is the same timeline that we saw, like from idea to filing. It's in this same timeline that we talked about. But here, once you file this in the PCT office, right? World Intellectual Property Organization window, you file there, and then uh, within 4 months or so, you get what is known as a international search report. At the time of applying for the patent, you must also say who do you want this patent to be, who should uh, examine this patent or search for the prior art for this. So you get an international search report. You can choose India or you can choose European Patent Office or any other. There are a dozen or so countries which are authorized to do this international search. And then you can choose any one of them and they will do the search and give you the search report. And then you can do, if the search report is favorable, you need not do anything. Even if it is unfavorable, you need not do anything. They will come to that a little later. This also will be published after 18 months after you ask them to do that. Then there is an optional process of examination by the PCT. Here, what happens is they will do an examination as if it's a national, a country doing it, country's patent office doing it, and then give you the complete opinion about uh, your application, technical, non-technical, everything about it. So that will have to be done within the 22 months. You will have to ask for the examination, you will paying a fee and all that. And then you have a choice. You can take this examination report and then keep it with you and apply in the national phase. That means you have 30 months or 31 months from the date of application for you to do this. Earlier, we said that within 1 year you have to make applications in different countries, but in this case, it will be 30 or 31 months, right? With some countries, you have to make it within 30 months. With some other countries, it will be 31. Now, this is called entering the national phase. For example, if you are an Indian inventor and you want to apply in, uh, let's say, Germany and England and the USA, you have to make those applications within this time period. And then they will all be different processes. There, whatever we have described about the examination and then the examination report, etc., the same process will continue, but it will be done by different countries, and they will have to pay fees everywhere. So that is uh, the advantage here is that you have a lot more time to figure out whether you really want to apply in different countries, and if so, how many countries? What is your business potential? Do you expect business from multiple countries, or is it enough if you want to apply in very small number of countries or none at all? You have a lot of time to make the decision. In the earlier case, you had only 18 months, 1 year time within this to make this application to decide whether you want to apply in other countries and all that. Now, with the PCT route, you get 30 to 31 months, which is a huge advantage, especially if you are planning to at the time of making the invention, you are planning to apply in multiple countries. This is a huge advantage because your expenditure of money and then your time to think and all that will be that much later. Now, we will see what a patent specifications contain when it is applied, or it will have a title which is supposed to be less than 15 words in India, and then it will describe what is the field of the invention. It is invariably a couple of lines, couple of sentences. What is the field of the invention? Then there's the background of the invention. It says why you made the invention. What is there? So, and you can also describe the prior art and describe the problems in the existing device, prior art or whatever. And then there is a summary of the invention, which gives a very brief description of what the invention is all about. And then there's if your patent has a lot of drawings, you will have to write a brief description of each of the drawings and then the detailed description of the invention. This is an extremely important part because the claims are to be read in conjunction with the detailed description. The patent law requires that if you look at the claims and if you don't understand it or you want details, all the details must be there in the detailed description. This is called claims being supported by the description, which is an extremely important thing. If you miss anything here, which doesn't allow a person skilled in the art to practice this, whatever has been claimed, the lack of completeness will be a reason for not granting you the patent. And then the patent also contains an abstract of the patent. This is mainly to help anybody search, because you can search in either titles or an abstract or in the full text. But abstract is something in which people can quickly search and find out what your patent is all about, and whether they want to dive deeper into your patent at all or not. Then you have drawings. These are the technical parts of the uh, patent, but it also has many other details like applicant's name, the nationality, and the address, and many other details will be there at the first page of the thing that we will have to supply all that. So these are the contents of the complete specifications. Now, there are, as I said, there are many other actions that need to be carried out. One of the things, for example, in India, what is required is if you have made applications within the 1 year period, or if it is through national phase with after 30 months, if you've made further applications in multiple countries, you have to keep the controller of patents informed about where you have applied. Or if the other officers give you a search report or an examination report, the contents of that also have to be revealed to the Indian patent controller. And then there are things like declaration about inventorship. See, what happens is, if an inventor is working in a company, they might be under a contract that whatever inventions that they make will belong to the company. Now the company has to prove to the patent office that uh, who has invented, and then they have a right to apply for this. So it was actually true and original inventor, it is called. So the inventorship, you have a form for that, and you have to fill it and then sign it and have like submit as an affidavit. Then, if you are employing a attorney or a counsel to do your job, or a patent agent, you have to give them a power of attorney that needs to be done. And if the patent is not granted, you will have to appeal for it to be rehearing. And if it is still rejected, you can approach the IP division. This is, I'm giving, as I said, it's examples because there's a whole lot of things that you might have to do. But these are the major ones, right? About the inventorship, and then the inventors have actually given the company the right to apply on their behalf. The company will own the patent. And here, more or less, will end the uh, prosecution life of a patent application. Now, there are two other kinds of patents that that might be possible. Assume that you make a patent application today, and then within the lifetime of that patent, you make improvements to that original patent. So what happens is that it protects improvements or modifications to your original invention. So this is called a patent of addition, because it is adding on to the patent that you have already applied for, or which has also been even granted. Then the inventive step of the invention above the mother patent is not necessary. Inventive step, if it is established for the mother patent, you don't need any further inventive step to be proved. And all you have to do is novelty is to be proved. That means you have made modifications which have not been done in time before. And then it's coterminous with the patent. That means if the patent, uh, uh, this patent also expires at the same date as the mother patent expires. That is after 20 years of its application. Now, there is no separate renewal fees for this. It will be treated as part of the thing. And then this is dependent on the main patent. That is, the mother patent is the one which will rule the whole thing. So this patent of addition quite often happens because there are smaller additional improvements that you make to your product when you release it and get, say, customer feedback, or you see that there are improvements possible. And then you make these things, and then you can get additional things so that is also not infringed by anybody else. Now, there is another thing called a patent, divisional patent. what can happen is that you make an invention that actually contains multiple inventions because you're trying to solve a problem and there are different solutions you are given to the same problem. Now, the patent office will say that you can apply for only one uh, technical solution to one technical problem. You can't give multiple solutions, cannot be claimed in the single patent. Then what they will tell you is that there is no unity of invention, as it is called in the law, lack of unity, and then you will have to take that and then split that patent into multiple patents. So this multiple patents may be filed either voluntarily that you realize this and you want multiple patents you can apply, or when required by the controller. Because the first examination report will say that there is no unity of invention, so it has to be split. But they will can take only one part of that patent and then grant that. But within that, you will have to do uh, split this into multiple patents. So here, what happens is the description and all that will remain exactly the same, but the claims will be drafted differently. But they should all be supported by whatever there is the description. You can't add any new matter; cannot be added. The patent retains the parent applications filing and priority dates for the newly disclosed subject matter. So the whole thing is actually like the same patent split into multiple patents. Each one of them becomes an independent patent application with separate examination, grant, and obviously for the fees and the renewal fees also. So multiple divisional applications are permitted if each is based on a distinct inventions disclosed in the original or the parent application. This is used strategically to safeguard claim scope and respond to unity objections. That means, as I said earlier, if the patent the examiner says or the controller says that there is no unity of invention, you do this so that each one of them will be a standalone patent. Now, so up to this point, we have only talked about what this happened. These are more practical kind of things that I'm going to talk to you about. As to, for example, uh, this is some notes about secrecy and what prior art means. You, an inventor should never reveal the invention to anybody else without a non-disclosure agreement, right? So otherwise, if the person assume that you want to get a spare part of the thing must be manufactured by somebody else, it's subcontract it out, and the subcontractor reveals what is being done. And if you don't have an NDA with them, then you are already have leaked out your prior art. So your art itself, for your own invention will become prior art for you. So you should not publish it in any form, or for example, paper or even a newspaper report. You should not display or demonstrate it even as a black box. That means a person who sees this instrument, for example, that you have invented, even nobody knows how it works inside. If it is displayed in public or it is offered to sell, then you offer it for sale, then its novelty is gone. So they should all be taken care of. So if you are a patent counsel and then you are trying to talk to a prospective patentee, you must ask these questions. Have you published this? Have you demonstrated it? Etc. There are some exceptions to this. For example, certain kind of inventions cannot be tested unless you test it in public. Let's take the simple example of a street light control system, let's say. So that can be tested only in on the streets. So people have already seen it, even though they don't know it, it's already been in public view. So that kind of exceptions apart, yeah, everything else you do reveal it to the public is it. So the important thing to notice in this. Just a moment, I'll shut the door because the dog is barking. So the prior thing that we must be very careful about is that even if it's an obscure language which is spoken by 100 people and there's a newspaper for that, even if you are patent is described in any form in such a newspaper in an obscure language, it is treated as prior art. So why I'm saying this, even though it is frivolous, is that novelty is an extremely important thing that you need to protect. That's the whole point of this last sentence. And then a little bit about what does a patent, rather an invention disclosure, what does it contain? It will have a title of the invention. It might be right or wrong. It really doesn't matter, because before, when you write the patent application, you will have to make sure that it's perfect. Then what are the problems solved by the invention? How have others solved this problem? If there is a solution at all, a brief description of the invention so that the person reading it understands it well. Then there's a detailed description of whatever you know already about the invention. There is a describe the invention, how it is better or different from your other solutions that you already know. Invariably, inventors are the experts in the field, so they know what is happening in their field, so they will be able to tell all this in this. And describe it with diagrams. If there are multiple ways of doing it, these are called embodiments, and then you have to give all this information about in how many ways can the same invention be practiced. And then if you have come across any literature or prior art, you must be able to reveal that also, because it is a good idea to say that if this is the prior art and I'm making an improvement, or my invention is over and above this. So that is also important. So this is what an invention disclosure contains. So of course, this is more for the practitioners, but it is better to guide the inventors about this. How to write an invention disclosure? This must be brief and precise. Uh, Many times, what happens is that people will start writing description which sounds like sales literature instead of technical literature. You must be you must make sure that it remains a purely technical document and not a sales document. Write down what is the field, what is the problem you have solved, how the others have attempted to solve the problem, how did you solve the problem. This is more or less the overall thing about what a invention disclosure contains. So these are further details: is block diagrams or flow diagrams. Why is it better than other solutions? What are the other benefits that are there? Even though you started out to solve one problem, there might be other benefits that the patent gives. So what are those benefits? So another important thing that you have to do is you have to know is that if somebody uh, infringes your patent, will you be able to detect it at all? For example, there are many times a testing method is uh, brought to you as a patent, something to be patented, a novel way of testing a known equipment. The disadvantage of that would be that if it doesn't leave any traces, if it is practiced only in the manufacturing unit of a rival or a competitor, you will never know whether they have infringed on your patent or not. So you have unnecessarily given out your technology, and then you have spent a lot of money, but you don't get any returns at all. So this is called detectability, and this is a very important thing that we should be considering if you want to apply for a patent, or if you want to advise somebody whether they should apply for a patent or not. So this is obvious. It should be understandable to a person not an expert in the field but has a knowledge of the field, so that they can draft a complete patent properly. Now, I've come to the final of this. If there are any questions, I'm ready to answer. If I know it, of course.
Uh, Hi, sir. It was
Right.
nice session. I have some questions regarding this from the start of our lecture. When we say we don't grant any patents for something that is not in consonance with the laws of physics, what do we mean by that? For let's say, like we
Yeah.
eventually,
Yeah. I'll
like
give you one example.
uh,
The classic example for that uh, is that uh, what is called a perpetual motion machine. I don't know whether you are aware of this term or not. What it says is that you assume that you say that you have invented uh, electric generator, or let's take a car, right? If you say that on a 1 liter of petrol, this car can run 100 kilometers or 150 kilometers. Now the question would be, what is the calorific value of the petrol, 1 liter of petrol? How much is the total energy that it produces? There's a limit to this. It's this chemistry and physics, right? This petrol burns, and the total amount of energy in whatever form, heat, light, everything, all put together, assume that it has a certain amount of energy it gives. Now you take the car and say that if it has to move for 150 kilometers, how much energy is needed? If they don't tally, that means the energy produced by 1 liter of petrol is far less than the energy required to move the car to by 150 kilometers. That means you are breaking the laws of physics, right?
Yeah, uh, okay. I get that, sir. Okay. But that has more to do with science. That is a very Newtonian way of seeing things. In the
Yeah.
modern age, let's say a law of physics can be I can't move past a ball directly. But in the
Pardon me?
modern age, I can't move through a ball, sorry, directly. Uh,
Yeah.
but when we see there are many new conceptions in quantum mechanics that yeah, we an electron can directly pass through a barrier. My
Yeah.
question
The tunneling,
essentially is my question
tunneling
essentially is
phenomenon. Yeah.
why do we have to restrict the patent that is very much a legal document. We won't be granting a patent for something that breaks the law of physics. Eventually, laws of physics are man-made only. Na? We progress in technologically. We get to know new things that are not in consonance with things we knew earlier. So
Yeah.
that is essentially my question. Why do we restrict it legally?
Yeah. Uh, the see, let's say, imagine that you get a patent. What do you do with a patent?
I use it for commercial purposes, of course.
You use it for commercial purpose. What else can you do with it?
Mm,
You can
it is a two-way
you,
thing.
you can you can give a license to somebody.
Yes.
That means assume that I take the license from you. I have the patent office has granted you a patent which violates the second law of thermodynamics, which is what I talked to you about. The 1 liter of petrol and 150 kilometers of, or 200 kilometers, whatever that number is. Assume that the patent office grants it. So, what do I feel as a person interested in this, in implementing that? If you have got a patent, it must work. So, I will give you money, right? And then I buy the patent from you. And then I try to implement it, it doesn't work. That means you have done harm to society. Correct?
Oh, yeah. In that respect, yes, sir. I got it.
Yes. So, see, whatever happens, still today, uh, tunneling is a very good example that you gave. People thought that it was impossible, but it happens. But if you could demonstrate it, assume that you invent something which apparently uh, violates the known laws of physics or known laws of science. If you can demonstrate that it actually works, then physics has to change. Correct?
Yeah.
For example, in modern quantum physics, the causality, the law of causality itself appears to be broken. That means the event occurs before the cause occurs. There are a couple of experiments which have shown that that might be possible. Now, in the normal set of circumstances, what do we say? There must be a cause and the effect follows the cause. But in quantum mechanics, it is apparently possible. I'm not saying that it is possible. It's apparently possible that the effect precedes the cause. Now, you are able to prove it. And then, based on that, if you are making an equipment, then you can get a grant. That's where, even though when I said that the proof of concept is not necessary, if you make an application like this, you will have to show proof. That's the important part.
Okay. So let's say if I demonstrate hypothetically, if I make a perpetual motion machine,
Yes.
And if I am able to demonstrate it, then patent office has to grant
Yes.
me a patent for it,
Yeah.
even
Then
though
it
it
has
is.
to grant you. Yes. That is where, when there is an apparent breakdown of laws of physical laws, then demonstration will become necessary. But till now, there are hundreds of perpetual motion machine applications. None of them have been granted. And the second law of thermodynamics has not been shown to be violated at any point till now. If there is an apparent violation of the see until E equals mc squared came, right? The law said that energy can neither be destroyed or created. Now there is energy can be created from matter. That's been shown. So up to that point, physics was one thing, and then it changed. So nuclear physics will come into picture, and then you can get patents on nuclear physics based uh, technical innovations. That's the difference.
Yes, sir. Got it, sir. Thank you so much. Sir, I have one more question. It is regarding uh, you told us about filing the PCT application, and we can choose which country need to do our examination or prior
Yeah,
art. So,
yeah,
are there any technicalities pertaining to that? Let's say I choose India or European Union. So, is
yeah.
there any difference? Or
Yes.
yeah,
See, this is partly my opinion, right? And partly what a lot of people believe. Okay. By my own experience, because I worked for Philips for nearly 15 years, and I've done a lot of prosecution work there. The quality of the examination report that you get from the European Patent Office, in my opinion, is far superior to that of any other country I've seen, including the US. Okay. Now,
yes, sir.
now the problem with that is that the European Patent Office charges you a lot of money. If assume that in India, if you ask for an ISR from in the Indian Patent Office, let's say that the fees is about 15,000 rupees. From the European Patent Office, it's nearly lakh of rupees. What do? If you have deep
Mm,
pockets and if you can afford that kind of money, and your patent is so important that you want it examined so thoroughly before you go ahead, and then assume that, for example, you are so confident about your invention that you want to apply in 50 countries. I'm just giving an extreme example, right? Assume that you want to apply in 50 countries. The amount of money that you're going to spend applying, even making the initial application, is so much that it is cheaper to get it examined by the best authority that is available in the world. That will be the European Patent Office. If you take me as a consultant, others might tell you that it is better to go for the US Patent Office. I'm not sure. But if you ask me, I'll tell you that if you have the money and if you are planning to apply in 50 countries, please get the examination done by the European Patent Office. That's the difference.
okay, sir. Got it. Thank you, sir, for the answers.
Yeah. So it looks like we fitted this exactly into the 1 hour time slot I was given, unless there are other questions. I don't have any limitation, not a problem. If there are questions, I'm ready to answer. So uh, let me ask a question in reverse. You came to this talk with a certain expectation. Has that been met to any degree? What do you think?
Thoroughly, sir. I
Huh?
found it very helpful. I found it very helpful. It was very practical as a
Oh,
law student, I would say.
you are a last student, is it?
Uh, what, sir? Yes, I am a law student at
Yeah.
University of Delhi.
University of
Delhi, DU.
Delhi. Yeah. So some of the things that I told you about is the kind of thing uh, that is good for uh, any students, and especially last students, to get to that kind of thinking. Why is the law where it is. That's why you asked a very good question. That what do you lose? Why does the patent office granted? Who knows? The point is this: that is, the law is there to prevent harm to others. That's one of the things. The other thing is, why is there the economic significance as a part of the Indian patent law, which doesn't exist in any other patent law, right? There is also one more thing. After you grant this, after the grant, after 3 years, you have to keep telling the patent office what you are doing to put that patent into practice. This is an Indian requirement. It doesn't exist in most countries. Why is that so? Right? That means you have to tell the patent office, I'm trying to get funding to start this factory, but I'm unable to do it. Or I'm trying to license it to other people, but I've not got any licenses. Or I've put it this amount of this, I've produced five, I've told him I've sold them, and I'm waiting for customer feedback. Whatever. You have to keep reporting to the patent office about your activities concerning your patent. Why is that required? The reason is that the patent law in India was based on socialist principles. That the patent is granted not to help only the inventor and the company, that is the capitalist part, but it is essentially for the benefit of the people of the country. Now, if you're not meeting, assume that you have made an invention and you are not putting out the product, but you are holding it because you have a monopoly. If that happens, the people of India won't benefit from it. That's why in Indian law we have the compulsory
Compulsory license.
licensing. Yeah. See, if you understand what the process behind this, what is the thought process behind it, you will understand why the law is there, and it is not easy to forget. So that's a very good question that you asked.
Sir, on that line only, you mentioned that for prosecution we moved to IP division of Delhi High Court. So,
Yeah,
like,
that is a final rejection. After the final rejection by the patent office, that it says that it cannot be granted, the only recourse now is to go to the Delhi High Court with the IP bench of the High Court. But right now, it is only exists in Delhi.
Delhi High Court has jurisdiction throughout India for that matter.
Yeah. If you're so strong to feel that you actually deserve a patent and the patent office is not granting to you, you could. Earlier, there was something called IPAB, which has now been disbanded. So it's no longer functional. So you'll have to go to the court.
Sir, I have just a very simple question that has more to do with my career related aspects. I have done BSc in physics and now I am doing LLB. I strongly want to go ahead in patent law. So,
Okay.
do you have any suggestions? Like, where should I start from? Like, should I go for a patent agent examination or should I go into prosecution for that?
Yeah, the patent agent examination is an absolute necessity. You have to pass that to become an agent.
Oh, like for the prosecution part for practicing in court,
Or
is that
any,
a necessity?
but the complete part, if you want to be an advisor to a patentee or an inventor and all that, if you want to call yourself a patent agent and help people get their patents, you have to pass the patent agent's examination and register yourself. There are two steps. One, you have to pass, and then you have to register yourself, and you should continue to maintain that registration.
Okay, thank you so
Yeah.
much.
And it's good that you have a physics degree, because science or technology degree is absolutely necessary.
Yes, sir.
Yeah. So I presume that we can end the session.
Yes, so thank you so much, sir. So I think it is an in-depth learning of patents. We had a detailed discussion of basics of filing and prosecutions. Quite insightful, engaging, and thank you so much. It was quite informative. I hope you all enjoyed the session, and thank you very much, Anil sir, for joining us today. And you all have a great evening ahead. Thank you so much, everyone.
My pleasure. Thank you.
Yeah,
Right.
thanks.
Bye-bye.
Bye.